Welcome to this in-depth guide on navigating U.S. immigration when the U.S. citizen petitioner has a serious criminal history, particularly under the Adam Walsh Child Protection and Safety Act, commonly called the AWA. In this video, we will break down how the AWA works, why the age of the victim matters, what USCIS and consular officers actually consider, how to think about K-1 versus spouse visas in complex cases, and practical steps for moving forward. As we move through the sections, we will use clear examples, diagrams, and quizzes to help you test your understanding. Here is our roadmap. First, we will explain what the Adam Walsh Act covers and why it is so crucial in family-based immigration. Next, we will focus on the decisive factor of the victim's age. Then, we will address what immigration decision-makers actually consider and what they do not reconsider. After that, we will compare the K-1 fiancé visa with the County Route 1 or IR-1 spouse visa for strategy. We will then discuss the nearly unattainable nature of the no-risk exception and how it differs from other waivers. We will finish with a practical action plan and a couple of quizzes to test your understanding. Let's begin. This content is educational and does not constitute legal advice. Immigration outcomes depend on your exact facts, documents, and governing law and policy at the time of filing. You should consult a licensed immigration attorney, preferably one with specific experience in Adam Walsh Act issues and waivers. If your case involves a serious criminal history, you may also need a criminal defense attorney for post-conviction relief. The Adam Walsh Child Protection and Safety Act is designed to protect minors from individuals who have committed certain offenses. In the immigration context, if a U.S. citizen petitioner has been convicted of a specified offense against a minor, the law imposes a severe bar on sponsoring a family member. The central concept is whether the offense was against a minor, meaning someone under 18 years old. If the offense was against a minor, the AWA likely applies and triggers an almost insurmountable hurdle, the no-risk exception, which requires convincing the government that the petitioner poses no risk to the beneficiary or to any derivative. If the victim was an adult, the automatic AWA bar should not apply, but the case is still subject to other grounds of inadmissibility and discretionary evaluation. This flowchart illustrates the threshold analysis for AWA applicability. We begin by acknowledging a past felony conviction. The critical decision point is the victim's age at the time of the offense. If the victim was under 18, the AWA likely applies, creating a severe bar that can only be overcome by the no-risk exception, which is extraordinarily difficult to obtain. If the victim was 18 or older, the AWA bar for offenses against a minor is not triggered, and the petition then proceeds under general admissibility and discretionary rules. The chart also emphasizes that immigration officers examine the statute of conviction and official records, not narratives attempting to relitigate the facts. The age of the victim is the hinge on which AWA applicability turns. If the victim was under 18, the AWA likely applies and makes approval extremely difficult due to the requirement to prove no risk. If the victim was 18 or older, the specific AWA bar for offenses against a minor should not apply. However, even when the AWA does not apply, the case is still scrutinized under other grounds for inadmissibility and discretionary issues. This single factor is often the difference between a case being potentially workable and nearly impossible. Quiz time. Which situation most likely triggers the AWA's automatic bar? Option A. The victim was 19 at the time of the offense. Option B. The victim was 17 at the time of the offense. Option C. Any felony conviction, regardless of the victim's age. Option D. Only violent felonies, regardless of the victim's age. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is the conviction where the victim was 17 at the time of the offense. The AWA focuses on whether the offense was against a minor, defined as under 18. Other options either ignore age or misstate the trigger. While any felony can raise serious concerns, the AWA's automatic bar is linked specifically to the minor status of the victim. The no-risk exception is the only path forward when the AWA applies, and it is extraordinarily demanding. USCIS expects compelling, professional evidence that the petitioner poses no risk to the beneficiary or any derivative. This may include expert psychological evaluations, extensive rehabilitation documentation, and a consistent record devoid of new criminal conduct. Even when petitioners present substantial evidence, approvals are uncommon. Time elapsed since the conviction and personal narratives, while helpful context, rarely satisfy this rigorous standard on their own. Immigration adjudicators do not relitigate your criminal case. They rely on the statute of conviction, the official court finding of guilt, and the sentence. Claims that the allegations were false, motivated by revenge, or unsupported are not evaluated in the immigration context. If you seek to change the impact of a conviction, the proper venue is the criminal court that issued it. Vacating or overturning a conviction is typically the only way to alter its immigration effect. It is ineffective to submit large volumes of documents attacking a victim's credibility or asking immigration officers to disregard a criminal conviction. Those officers cannot undo a criminal court's judgment. If there is a basis to challenge the conviction, that must happen in criminal court through recognized procedures such as vacature or other post-conviction relief. For immigration filing, focus on official records, the exact statute and elements, certified dispositions, and verifiable rehabilitation evidence like stable employment, community support, and counseling completion. This timeline lays out a typical sequence for a complex case. First is an initial consultation with an attorney experienced in AWA issues. Next comes records gathering, certified judgments, the statute of conviction, and relevant police or court records. Then, a focused assessment determines whether the AWA applies based on the victim's age. If warranted, the petitioner consults criminal counsel to evaluate post-conviction relief. After that, the immigration strategy is chosen, such as K-1 versus County Route 1 or IR-1. The petition is filed, and the admissibility decision occurs either at a consulate for immigrant visas or during adjustment of status for K-1 entrants. Where applicable, waiver routes are considered, including the very difficult no-risk exception or other general waivers. Finally, the case reaches an outcome depending on the facts and evidence. The K-1 fiancé visa allows entry to the United States for marriage, followed by adjustment of status. The County Route 1, or IR-1 spouse visa, is processed entirely abroad and results in the beneficiary entering as a permanent resident. In high-risk cases, or where AWA could be implicated, many practitioners observe that the spouse visa may provide earlier clarity because the admissibility decision is made at the consulate before entry. However, if the AWA is triggered, both paths face the same exceedingly high no-risk standard. Comparing K-1 and County Route 1, or IR-1, the K-1 route involves entry on a fiancé visa and then adjustment of status within the United States, which creates multiple adjudication points. That can prolong uncertainty in high-risk scenarios. The County Route 1, or IR-1 path, concentrates the decision at the consulate, often providing earlier clarity before entry. Both paths face the same no-risk barrier if the AWA applies. K, the first of, may achieve faster initial entry, while County Route 1 or IR-1 often leads to green card status upon arrival, albeit with a longer pre-entry processing period. This table summarizes typical waiver scenarios. If the AWA is triggered because the offense was against a minor, the only path is the no-risk exception, which is extremely difficult. If the victim was 18 or older, the AWA bar should not be triggered, and the petition proceeds under general admissibility rules. Other grounds of inadmissibility may still apply and have their own waivers with varying standards. In situations where there is no statutory bar but there are discretionary concerns, presenting strong positive equities and rehabilitation evidence becomes essential. Here is your second quiz. In complex cases with potential Adam Walsh Act issues, which route often provides earlier clarity on admissibility? Option A, K-1 fiancé visa. Option B, County Route 1 or IR-1 spouse visa. Option C, both are identical in timing. Option D, neither. Admissibility is only decided after entry. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is the County Route 1 or IR-1 spouse visa. This path typically results in an admissibility decision at the consulate before the beneficiary enters the United States, which can provide earlier certainty. In contrast, the K-1 visa involves adjustment of status after entry, introducing additional decision points, and potentially prolonging uncertainty. Here are practical steps. First, retain an attorney who specializes in AWA and waiver issues. Next, gather certified court records including the judgment, statute of conviction, and sentencing documents, and verify the victim's age from official sources. Consult with a criminal defense attorney to evaluate whether post-conviction relief is appropriate or possible. Decide between K1 and County Route 1 or IR1 based on your risk profile and timelines. Assemble proof of rehabilitation such as counseling completion, stable employment, and community ties, and ensure there are no new offenses. Prepare organized evidence and, where needed, expert evaluations. Remember that attempting to relitigate the facts in the immigration process is ineffective. Focus on what officials actually consider. Finally, monitor evolving policies and adjust your strategy with your attorney's guidance. This mind map organizes the moving parts of an AWA-involved case. The legal team includes both an immigration attorney familiar with AWA issues and a criminal defense attorney for post-conviction strategies. Records encompass certified judgments, the statute of conviction, sentencing documents, and any available reports or dispositions. Risk assessment focuses on verifying the victim's age to determine AWA applicability and identifying any general inadmissibility issues. Strategy choices include K1 versus County Route 1 or IR1, with attention to timing and whether the key decision will occur at a consulate or during adjustment of status. Evidence includes rehabilitation, expert evaluations, community support, and employment records. Outcomes may range from attempting the no-risk exception to pursuing general waivers, facing a denial, or benefiting from successful post-conviction relief. Here is a quick glossary using markdown formatting. It defines the Adam Walsh Act, what a specified offense against a minor means, the no-risk exception, admissibility, adjustment of status, and the County Route 1 or IR1 spouse visas. This should help standardize terminology as you discuss your case with counsel. Now, let's move toward our key points. The essential points are as follows. The victim's age is decisive in determining AWA applicability. The no-risk exception is extraordinarily difficult to meet. Immigration adjudicators do not relitigate the criminal case. They rely on official records. If appropriate, post-conviction relief can change the immigration consequences. Finally, choose the visa path strategically, in consultation with experienced counsel. To summarize, the AWA creates a very high barrier when the offense was against a minor. If the victim was 18 or older, the AWA's automatic bar should not apply, but other grounds of inadmissibility and discretionary issues may still control the outcome. The strategic choice between K1 and County Route 1 or IR1 can affect timing and certainty. Keep your focus on official records and explore post-conviction relief where appropriate. Engage an attorney experienced in AWA issues at the earliest stage possible. Thank you for watching. If this video was helpful, please like, share, and subscribe. We would love to hear your thoughts and questions in the comments. Your engagement helps others find this information when they need it most.